All right, good afternoon, everyone. Thank you for being here with us today. My name is Carlos Ray. I'm the Program and Marketing Coordinator for Meriwether and Williams Insurance Services, and I'll be your host today. Welcome to the Construction Contract Review in the time of COVID and post-COVID, presented by the City of Los Angeles and Los Angeles Metro Contractor Development and Bonding Program. We have a great presentation for you today, presented by Mr. Aaron Flores from Hunt Ortmann Attorneys. We'll get into that in just a second. As we normally do, I want to get into a couple of housekeeping notes just to make sure we have a smooth meeting and everything goes well. So just bear with us for just a second. So the first thing is just, you can ask questions throughout the presentation. Feel free to submit them in the chat or raise your hand, use the raise your hand feature. And we would love to hear you ask them verbally, just to kind of keep that human interaction going. I know we've been on Zoom for a while, but let's keep it that way if you can, if you feel comfortable, but either way is fine. And then if you're going to be on camera, just be mindful of your surroundings. If you need to go on mute, turn your video off for any reason, that's okay, and as well as your sound. And then next is a survey. Here's a link to that. We just want to know what you thought about today's workshop, and I'll make sure that I get that information in the chat for you as well. And we just want your feedback. This helps us plan for future events and future topics that we want to bring to you guys to help you grow. And so with that, I want to just tell you guys about a couple of upcoming events we have. So starting tomorrow, we have a Navigating City Contracting Opportunities with Councilmember Curran Price tomorrow at 3:30. And I'll make sure I put registration information for that. That's free, just to learn about, how to do business with some of the different agencies, including LAWA, the Port of LA, LADWP, and so on. So I'll get you guys a link for that. And then the program is also hosting a Metro Bidding and Estimating Academy, which starts next week. So we still have some spots available if you want to register. Contact your account manager if you are a member or enrolled in the Contractor Development and Bonding Program. If you aren't, just feel free to give us a call or email us at the email here below, and we'll get you set up and get you an application to get signed up for that training academy. And it's absolutely free. It's going to cover a lot of different topics about how to bid and estimate on a project with Metro. So just wanted to let you guys know about that. And so without further ado, we'll get started with our presentation, and I'll turn the floor over to Mr. Aaron Flores.
Thank you so much, Carlos. I appreciate that. Let's see. I need to share my screen here. Let's see. There we are. All right. Can everybody see my screen now?
Yes, looks good.
Excellent. Again, Carlos, thank you for the opportunity to present the seminar. Thanks for all the hard work you've put into it. Today's topic is construction contract review in the time of COVID and post-COVID. I've done a lot of these presentations, and COVID really provides an opportunity for us to discuss, the things that are happening on any given construction project or a construction contract, but dive into the particulars of them, given the fact that we have a new issue on the scene, so to speak. If you need to reach me at any time, there's my email address. Feel free to reach out to me with any questions, or if you need any help. Today's agenda, we're going to be talking about the future risks of risk management, and this is really the area from a risk management practice where you see the impacts of COVID. For instance, change orders, health and safety costs that amount, stoppages, starts of a project, etc. We'll talk about how to legally handle some of those future risks through the doctrines of force majeure, as well as impossibility. And then in our presentation, we'll turn the corner a bit, and we'll talk about contract review process, right? In light of these future risks and some of these legal doctrines that you can take advantage of, how do you implement them? And so we'll talk about how you put together a contract review process. And then we'll do a deep dive, the deep dive going into the key contract provisions, discussing how they are affected by COVID, as well as how they are affected and how they should be treated in a post-COVID world. So let's jump into it, and let's talk about risk management. So we start off our discussion really just with a generic summary of risk management, right? This is the general process or the general procedure for risk management. We start off with risk identification. We then analyze that risk, and then we treat that risk with a particular technique. We either decide to avoid the risk altogether, risk avoidance, or we decide to transfer that risk through some form of contract, or we implement some type of loss control with insurance to protect us against that loss, or we decide to intentionally retain that risk, right? It's a known risk, an identifiable risk. We decide nonetheless to retain it, not transfer it with a contract or subject it to insurance, but we retain it. And through those techniques, then you implement them, right? We identify the risk, we analyze it, we treat it with a particular technique, we implement it, and then we continually monitor and review. But this is the infrastructure or the framework in which we should be thinking about future risks where COVID will appear and where we'll discuss it. So again, when we're talking about COVID, it's a future risk that may be unforeseeable at the time the parties entered into the contract, right? We'll discuss this more about how to look at this and analyze it post-COVID. But in terms of pre-COVID or during COVID, this was really a future risk. And some of those costs and risks associated with it included health and safety compliance, right? When can I allow my workers to continue working versus having to send them home, and the host of labor issues associated with that. It may include delay, disruption, and acceleration, right? Getting the project back on schedule if there's been some interruption. It may be the extended general conditions costs, the price escalations that occur when there's a change in the market. And it may just boil down to the quality of the scope being performed, because the persons performing the work may be in limited supply or not available at all. And so the scope quality may be affected as well. Future risks and contract. And so what we're really touching on in these future risks, when we get to our risk management techniques, it's risk transfer through the contract, these written provisions, what we'll talk about, and the loss control, right? Is there any insurance or anything available to help defray the costs of those losses? So when we talk about risk transfer, there are many standard form industry construction contracts that have already addressed a lot of these issues. And so that's the good news, is project impacts, whether they're time or cost. The infrastructure for handling those has been set up in a majority of the standardized construction contracts, as well as contracts with public agencies. So for instance, in the AIA, we have present under the general conditions, section 8.3.1, that things that are beyond the contractor's control are going to be compensable, and we see that throughout the AIA 201 general conditions standard form, and that the owner also has the right to suspend or delay or interrupt the work, right? But it's rather clear in the AIA contract that any risk of impacts that are outside the reasonable control of the contractor are going to create a basis for entitlement for additional time or costs. Same thing with the standard consensus docs. 200 section 6.3.1 deals with the issue pretty straightforwardly, as well as in the specifications. In terms of the federal government, the federal acquisition regulations expressly identify epidemics and quarantine restrictions as grounds for excusable delay. And so in terms of risk transfer, we have some infrastructure here that can be favorable for contractors if the impact of COVID was not foreseeable and the cost burden was excessive. So we've talked about the risk transfer that is triggered here, but the loss control, right? And these are things that are dealt with through insurance, right? Many court cases are still making their ways through the courts of appeal and things, but there may be some business interruption insurance coverage for certain types of projects. And then the federal and state legislation that has stepped in and continues to step in will certainly play a role in this loss control, right? So when we're talking about future risks, we're talking about the risks that COVID can cause the project impact, and those things are specifically dealt with by risk transfer, right, through the contract and loss control. So when we're talking about the framework of managing this risk, we have some perspective now, right? We're thinking, okay, we're going to be looking at the contract as well as possibly some insurance and legislation issues to try to help us understand how to manage this risk. So that being said, let's talk for a minute about the legal doctrines that are applicable to this risk transfer and this loss control that we've identified here. Again, we're talking about future risk, and I'm sure you've heard the term force majeure, and it stands for a broad legal doctrine, but generally the doctrine stands for the proposition that a contract obligation will be suspended or excused due to some type of unforeseen supervening event, right? And the Civil Code section 1511 identifies this for us, if it's an irresistible superhuman cause or by the act of the public enemies of the state or of the United States. You may be familiar with the term of an act of God, right? The force majeure. But the Civil Code draws an important line that we must acknowledge. It says, unless the parties have expressly agreed to the contrary. And so the statute is essentially confirming that if the parties have agreed in writing in their contract how to deal with a COVID impact or deal with a virus or epidemic or pandemic, then the fact that it may be irresistible or superhuman may not in itself be enough to provide the contractor relief. And that is because courts traditionally will try to enforce the express agreement of the parties as opposed to trying to rewrite that agreement, right? And so it's very important that we first look and see what is actually written into the contract to see if the parties have expressly agreed concerning the future risks of this project impact, right? Have they agreed about an epidemic or pandemic or virus? Have they agreed about the cost impact? Have they agreed about the time impact for that? If so, there's a good probability that courts are going to actually enforce that. In addition to force majeure, courts have developed this doctrine of impossibility and starting to broaden this doctrine of force majeure and impossibility. Courts have stepped away from objective harsh impossibility being required, but modern cases have really said, look, if there's some type of impracticability economically due to excessive and unreasonable difficulty or expense, right? Those are the buzzwords that you want to remember and commit to memory. Is it's not just enough that it's impracticable. Instead, it has to be excessive and unreasonable difficulty or expense, right? It may be that something was not foreseeable, for instance, a COVID impact where everything is shut down, but has that impact been excessive and unreasonable in terms of difficulty and expense? The good news is that, like we talked about before, existing industry contracts have kind of set up a framework to deal with the issue pretty fairly and essentially follow what is provided for in the restatement second of contracts, which is essentially 3 different scenarios that courts will follow. One is where performance is just impracticable, right? That the burden is so excessive that it's impracticable, and that was unforeseen. Secondarily, it could be that the circumstance has destroyed the value of the other person's performance, right? And that as a result of that, your own purpose in making this contract is frustrated, right? If the other party's performance is no longer valuable to me, why would I then provide my contract obligations if I'm not receiving anything valuable in return, right? That could excuse the obligation. Or in a third scenario, where you will not receive the agreed exchange for your own performance, then your obligation can be discharged. But courts have generally followed these legal doctrines of force majeure and impossibility, again, expanding it to address the issue when an unforeseeable and unexpected project impact occurs that is excessive, right? Both economically, potentially, as well as time-wise. So this is the legal framework that we want to look through. Again, the industry contracts have done a reasonable job of setting up the infrastructure. And so when COVID landed, we at least had some form of an infrastructure to evaluate the issue, right? And at the time that the contracts were entered into prior to COVID, parties could truly say no one had any foreseeability as to COVID. And most parties would agree that the impact of COVID on most projects has been, extensive. And there's no dispute that it falls with under the force majeure or impossibility doctrines. So there is entitlement to additional costs and things that we'll get to. But a bigger question presents itself is, well, what about new contracts during and after COVID, right? Aaron, you just told me that the issue about foreseeability and the excessive cost is all measured by looking at the time the parties entered into the contract. And at that time, prior to COVID, no one was expecting to have a global pandemic. But during the time of the pandemic and moving forward, now arguments can be made that parties entering into new contracts actually are able to foresee the potential impact of COVID and shutdown orders, et cetera. And so the question presents itself as, well, what is in the contract during COVID and post-COVID, and what's foreseeable, right? It could be that pre-COVID, the contractor is entitled to extra time and extra work cost for dealing with a COVID issue or shutdown issue. But that same contractor who may have entered into another contract, within the last few months and tries to bring a change order for COVID-related project impact may not legally have a good case because of this exact scenario, what's in writing and what was foreseeable at the time they entered into the agreement.
Hey, Aaron,
So
we have a question. So what are the precedent cases or major historical events that cause the notion for force majeure?
Yeah, so force majeure has been something that is rooted in the common law, as well as something that has been codified in statutes, as well as published cases. And so if you go through our outline, our PowerPoint, there are a few key cases here that are cited there. Those are the modern cases that are useful, but there is actually some case law on old pandemics, Spanish flu, things of that nature that have actually in the early 1900s formed some of the case law on force majeure and on the doctrine of impossibility. So if you look at the earlier portions of the slides in the PowerPoint, it's there. And so that's why I say there was some framework already in place, both in the legal doctrines, but also in the construction contracts itself. So now we turn the corner in our presentation here, and we're really talking about now is, okay, we've defined what these future risks for COVID are in terms of the risk management practice and activity. And we've defined some of the legal doctrines that will apply, understanding that these things can be limited by the contract as well as specific project facts, right? But now we ask ourselves the question, okay, so what do we do with this? Well, what we do with it is we package it into our contract review process, and we'll jump into that and explain how to put together one of those processes. And then we're going to get into some of the key contract provisions to be aware of, right? So here comes the practical component of the seminar in terms of how to implement what we're talking about. So again, when we're talking about the contract review process, we're really talking about risk management. It boils down to the risk avoidance, transfer, loss control, and risk retention. And in terms of the contract review process, there's really two different forms of contract review. There's contract review for the purposes of negotiation, and there's contract review for the purposes of implementation. The conversation today will be talking about implementation versus negotiation. But in terms of implementation, right, we're reviewing the contract to understand how it will operate and how we need to schedule our own operations as a contractor so that we can comply with the contract and also be prepared for any unexpected circumstances on the project. That's really the purpose of the contract review process. So my recommendation to my clients is always to assemble a team for contract review and include members of different phases of the project process, right? The parties who are involved in licensing, parties who are involved in employment H&R, right? Get somebody from each one of these activities. And maybe if it's your small company, it's just one person, that's fine. But get somebody who is involved in each one of these activities to review the contract with you. Why is that? Because they will be able to understand perhaps a little bit better their specific area and be able to provide input. And so essentially what we do here is we identify objectives and we identify risks, right? Every project has labor, materials, equipment, scope, and cost, right? Laid out over a time duration, which is the project schedule. And so there's no question for a contractor if they've done that process of spreading out their LME over the project schedule to be able to identify where that profit is, right? You need to know where that profit is, know what scope it's going to be in, know what timing it's going to be in, know where your saving clauses are in your contract, which will benefit the contractor, right? If we can save dollars on a particular line item, that goes to our benefit. Know where that's at, right? Also know where the notice and claim deadline obligations will arise. If you anticipate that there could be a differing site condition at a certain point in time, make sure that you understand the notice provisions for change order requests, as well as providing claim notification and the deadlines for those notifications, right? So we identify where those profits are going to be, some of the challenges to getting to some of those profits, and you identify the specific provisions in the contract, either savings clauses or notice and claim deadlines to protect that profit. On the other hand, you identify the risk and you take the similar approach. Where are the potential losses at? How can those risks be packaged, right? We talked about this a little bit. Insurance, right, is one way to do it. Indemnity, right, through a written contract, asking somebody, another party to indemnify you. Possibly payment or performance bonds, right? This would be one way to retain the risk, even though the surety is going to pay it and ask for reimbursement. And again, just as important to identifying, where the potential profit is, where the potential loss is, you need to be aware of, again, the notice and claim deadline obligations, identify them and follow them. Then once you're able to identify, here are areas of profit, here are areas of potential losses, here are our contract provisions that apply to these potential profits or these potential losses. Then you implement how you want to treat those risks, right? The risk of profit, the risk of loss with the particular technique. And then you continually monitor and refine it. The contract review process is not rocket science. It's something that just merely has to be done consistently and as a team. I've had cases and general contractors that I've deposed who tried to do this process but didn't do it as a team. And I can recall one offhand where it was a CM at risk. So the construction manager is operating as both the construction manager and the general contractor, and the superintendent or project manager that I was deposing on this matter was writing emails telling the project owner that the project is failing because the owner did not hire a construction manager, and that if a competent construction manager was at the project wouldn't be failing. Problem was it was a CM at risk contract. The general contractor was serving both roles, the construction manager and the general contractor, because this particular project manager was not part of the team that reviewed the contract. He didn't know this basic fundamental difference between CM at risk versus just being a standard general contractor. And in deposition, he affirmed his misunderstanding, and it didn't go well. So it's simple. It's not challenging, but it has to be done. So that That said, we have our understanding of how the process works in terms of the contract review, the team members, what we're looking for in terms of profit and loss, how to spread that over the construction schedule and be aware of the contract provisions that are related to it. Let's now talk about some of these specific contract provisions, keeping in mind how they might be treated during COVID as well as post-COVID. All right, so here are the provisions that we're going to cover: schedule, payment, prompt payment, differing site conditions, indemnity, right, the risk transfer, change order procedure, termination, claims, and dispute resolution. And before I get into each of these contract provisions, just by way of curiosity, I don't know if you can raise your hand on the Zoom, but how many of you have had to negotiate a change order that included some type of COVID impact on one of your projects?
Yeah, please use the raise your hand reaction on Zoom just so we can kind of get a counter percentage.
Got it. So not sure how many, but so
yeah,
I'm not sure.
I didn't see any hands.
Okay, so and that may not be surprising. I was curious to ask the question because a lot of my clients have actually been able to settle up these change orders pretty easily. Again, because that infrastructure was already in place in terms of the legal infrastructure, as well as some of the contractual infrastructure in terms of risk shifting. Although the biggest challenges in terms of COVID change orders, if you could call them that, is really not that there's been an impact, and not that the contractors, not whether the contractor is entitled to any kind of cost or time, but it's really the amount of time, right? It's really the proof in the amount of entitlement that the contractor is asking for. And so I assume that that's the experience of most contractors here. So first, let's talk about schedule and delay. Generally, the complexity of the schedule is going to be proportionate to the complexity of the project, right? And when we're talking about what's compensable under COVID, the traditional rule applies that generally you have to be able to prove that there was some type of delay to the critical path of the project. If you can't prove that there was no delay on the critical path, you may not be entitled to extra time or extra compensation. So the critical what and a delay. Some contractors, if they have a straightforward COVID claim that there's impact there, the answer of what caused the delay is very easily answered. However, in projects where you have multiple causes, one of which may be COVID, but others may be the contractor's own delay or the owner's delay, you need to understand how those delays all relate to each other so that you can actually isolate the additional time caused by COVID and identify the time and cost that you're entitled to as a contractor. So being able to answer these questions and prove that there was delay in the critical path is absolutely critical. So in terms of best practices of dealing with this, use a reasonable baseline schedule, update the schedule once a month, use look-aheads and revise them accordingly, and identify in the contract who owns the float time, right? Who's going to own any slack in the schedule. And probably one of the best practices you can do is to use a fragnet. This is basically a sequence, a cluster identifying new activities they're going to add to the existing schedule and how it's going to impact it. In terms of time extensions, the time extension, if done early and done in advance, can give the owner options in terms of how they want to handle the impact. Do they want to deduct scope and avoid a potential delay by deducting scope? Do they want to accelerate and pay the contractor additional dollars to accelerate their work activity? One of the things that we're always concerned with when it comes to time extensions is no damages for delay clauses, right? If you're not familiar with these clauses, Their purpose is really for the owner's benefit or the party who is in the higher tier position, so that an owner is not responsible for the contractor's field office or home office overhead during a delay, but instead is only responsible to give the contractor a time extension, right? Something that you want to be aware of if that's in your contract. Liquidated damages in California are presumed valid, and there's a question usually of comparative fault. So in your liquidated damages provision in your contract, it's going to be presumed valid, and if you go past your completion date, there's a per diem amount. But the question really becomes, what was the cause of the liquidated damages, right? And if you have your CPM schedule that you've maintained and updated, chances are you're going to be able to prove up the impact of the COVID delay that caused your project. Let's keep going here because I want to identify what you may see in terms of a no damages for delay clause. So this is a standard no damages for delay clause, and you can read it for yourself here, but it's exactly what we've been talking about, that the extension of time is the only compensation. It's the sole remedy, right? And if you have a COVID change order where you've had project suspension or shutdown or delay, you want to avoid the liquidated damages. So you want to get an extension of time so that you're not faced with liquidated damages at the end of the project. But you also have real costs in terms of field office and home office overhead as a result of that project stalling. And the question usually arises from contractors, is a no damages for delay clause enforceable exactly how it's written? And the good answer to that question is that no. If no damages for delay provision is written in your contract, but the amount of delay is now unreasonable in relationship to the overall contract, then a no damages for delay clause may not be enforceable. Meaning that if the amount of delay on your project due to the COVID impact was unreasonable, then this no damages for delay clause may not actually be enforceable, and it may not preclude you from recovering home office or field office overhead for that delay. Let's keep going and we'll get into payment. So the traditional payment custom and practice for a construction project is to use the conditional and unconditional waivers. I'm sure most of you are familiar with this. If you are not, feel free to shoot me an email and I'll provide you the forms. And the payment provisions are going to preserve the parties' respective rights, right? If there's defective work, if there are third-party claims, if there's any type of evidence that the contractor is failing to perform, then the owner may be entitled to make withholdings and delay payment. One of the key provisions in payment clauses is a pay when paid clause. It used to be pay if paid. And so a contractor could hire a sub and say, if I get paid by the owner, then I will have the obligation to pay you. Courts ruled that those were not enforceable, and parties began using pay when paid, which would say when the owner pays the general contractor will then pay the subcontractor. Pay when paid provisions can be enforceable. And the question usually arises, well, how long does a subcontractor have to wait? And recent case law came out last year basically said that a party does not have to wait for an undefined period of time while the owner and the general contractor work out their payment dispute before the subcontractor's payment is owed by the general contractor. And so we get back to this idea of unreasonable amount of time, right? If there's an unreasonable delay in project schedule, you may be entitled to compensation. And if there's an unreasonable delay in the owner making payment to the general contractor, you may not be required to wait under a pay when paid clause. Another important one under payment provisions is the continued to work clause. This typically presents itself when there's a change order dispute and the contractor throws up their hand saying, you're going to put me into bankruptcy if you force me to perform this extra work without a change order. The contract will generally have a provision that says, and in the face of a disputed change order, the contractor agrees to continue work and continue under protest at the direction of the owner. And these can be very powerful tools against the contractor, because even if the contractor is entitled to a change order and extra costs and time, they may have to continue work, notwithstanding the fact that they're entitled to that extra time or cost and actually come out of pocket, right? So things to be aware of, things that could increase your risk for a loss on your project. So now we get into the prompt payment statutes, right? We're talking about, the time factors, we're talking about the payment factors, and a combination of them coming together is really the prompt payment, and where a delay in payment is going to cause a penalty that a claimant can recover. These prompt payment statutes, they're unique, but essentially the public policy behind it is to ensure that parties are timely paid for the work that they perform. And so the state has set up a variety of prompt payment statutes that basically create timelines and punishments if those timelines are not met for payment. So generally on a public work of improvement in California, a claimant can collect 2% per month interest penalty against the contractor, not an owner, against the contractor, plus the fees and costs for pursuing those payments. And so that's 2% annualized, so that's 24% annually. You can't beat that anywhere right now in the market. And so I've had contractors who were able to sit on a payment claim while it worked its way through litigation, and 2% per month over a full year on a couple $1 million adds up real fast. So things to be mindful of. Generally requires the progress payments to be made to a sub within 7 days, and retention within 7 days. Progress within 10, retention within 7 days. There's also prompt payment penalties applicable to a public owner, local agency owner, but they're generally less, right? The progress payment will be only 10% interest penalty annualized, so not 2% per month, 24% annualized. But you can get 2% retention from an owner, a public owner, if they don't timely make payment to you. So things to be aware of when time and payment intersect. And again, more rules here. Now, there are rules related to making a prompt payment claim concerning the defense. And an owner or a general contractor can refuse to pay timely if there is a good faith dispute, right? So there's evidence that there's some kind of claim against the party who's seeking payment, or there's defective work performed by that party, or they're not meeting the project schedule. An owner or a general contractor can say, well, I have a good faith dispute with you, and now I'm going to withhold 150% of the disputed amount in order to protect themselves. So time and payment are incredibly important. And when payment is not timely made, you have these prompt payment statutes that provide you an opportunity to recover a quite substantial penalty. The key with prompt payment statutes and being able to trigger them is that most contractors will require extensive documentation and a payment application, which subcontractors struggle with. And so until that subcontractor has provided all of the documentation as required by the contract, then the payment application is not yet triggered. And so I've had many clients, subs, who would say, hey, I'm owed the money, I'm owed prompt payment, but unfortunately they did not have their payment documentation organized well and properly submitted. And so what would have otherwise been a fantastic prompt payment claim is lost because the payment documentation was not properly submitted. It didn't trigger the payment obligation. And if the payment obligation wasn't triggered, then you can't get to the prompt payment violation. But they can be incredibly powerful. So beyond time and payment, let's talk about some of the substantive things that we encounter on projects that we'll see in these contract provisions. And what we'll see is provisions relating to differing site conditions. Generally two types, right? The first type is something that may have been disclosed, but the degree to which it was understood was not clear based on the bidding docs. That's type 1. So if it's a particular type of soil condition with water at X level, type 1 is you get out there in the field and lo and behold, the water is at a much higher level that you didn't anticipate. Type 2 is something that the parties really had no clue was going to be there and it wasn't disclosed, right? The classic example is, dinosaur bones on a project that nobody was aware of. That's type 2. No one expected it to be there, and both may be potentially compensable. So again, just some examples of the different 2 types. The key thing here is that when a party is entitled to a change order for a differing site condition, it's in large part going to be dictated by what's in the contract, right? So here's an example of potential profit and potential loss, right? If you're doing heavy grading work on a piece of property that doesn't have a lot of historical data associated to it, this is an area where you're going to want to say, okay, what are my notice for change order provisions and my notice for claim provisions that I have to follow just in case I run into this? I might have the opportunity to make money. Might have the opportunity to lose a lot of money, but differing site conditions is a classic scenario. The dinosaur skull. And I usually use this as an example of, this would be a type 2 differing site condition, but not necessarily, right? If the parties were just told in the contract documents that there was a dinosaur graveyard in and around the area somewhere, then this could actually be a type 1, right? It's what was actually disclosed and what were the parties aware of is what makes it a difference between a type 1 and a type 2. And in most contracts, a type 1 change order, where it's just a matter of degree in terms of like the water level, for example, most construction contracts will try to shift the risk of that type of differing site condition onto the contractor. So you'll see provisions that place great inspection obligations or recitals that the parties have inspected the property and things of that nature to try to shift that type 1 differing site condition to the contractor. The type 2 is much more easy to deal with. If no one anticipated there was going to be dinosaur bones on your project and that was not foreseeable, chances are that's going to be a compensable differing site conditions. The Public Contract Code 7104 is the statute that obligates a public owner to pay for a differing site condition. Let's keep moving here. Now we get to indemnity. Again, we're talking about risk transfer through contracts. Indemnity is one of the great areas where this is manifest. When we're talking about indemnity, we're talking generally about 2 different duties that are wrapped up in the term indemnity. It includes the duty to indemnify. It's the obligation to pay money on behalf of another, so there's an underlying loss. But it also includes the duty to defend, right? If someone is suing you and you're indemnified by somebody else, that other person has the duty to hire a lawyer and defend you or pay your litigation costs. And so when we talk about indemnity, it's the duty to defend a lawsuit, but also to indemnify, to pay out the actual loss. And there are generally in California 2 types. One is type 1 is going to indemnify somebody against all liability regardless of their culpability, right? You'll see this with owners being indemnified or general contractors being indemnified. Type 2 is really a lesser form that's focused on not the active negligence or sole negligence of the owner or the prime contractor, but based on their passive negligence, right? Or negligence that or losses that they may be sued for that arise out of your own scope of work. Courts have generally limited type 1 indemnity and limited it only to type 2 or what's called type 3, which is kind of like a comparative fault type of indemnity. And the current state of law, like I said, type 1 is basically gutted. In most construction projects, and I think I would say all construction projects at this point in time, a subcontractor cannot legally defend or indemnify a prime contractor or an owner for losses that don't arise out of that subcontractor's scope of work, nor for the prime contractor's sole negligence. Those are not going to be allowed. And so it's really limiting it to the kind of this comparative fault, whatever the subcontractor actually cause in terms of damage, that's what the scope of the indemnity is going to be. But you can see, because these indemnity agreements are in writing in a contract, they can be written to try to shift the risk to one party or another, and so they have to be read very carefully. In terms of the duty to defend, if it's ever triggered, the subcontractor elects to pay for the defense. Either they can defend with counsel of their choice and defend the owner or the general contractor, or they can pay a reasonable share of defense costs that are allocated to them for defending the owner or the prime contractor. The key thing when it comes to indemnity, like any other risk transfer via contract, is to read the contract and understand the indemnity provisions. If you have a duty to immediately defend and indemnify whenever there's any type of claim against an owner that may arise out of your scope of work, then you're going to want to, from a risk management perspective, be aware of any third-party claims on the project that may arise to the level of filing a lawsuit, because that is going to trigger a pretty substantial cost exposure for having to either select counsel and hire an attorney, or to pay the cost of the defense for the owner or the prime contractor. And so in terms of potential losses, this is one of those potential losses that you'll want to be aware of during the contract review process. Let's get to change orders and change order procedure, which is extremely important here. So the way to look at a change order is really that this is the modification of the legal contract, right? We entered into the contract originally with at the beginning of the project. Now we've gotten to a situation, and maybe this is the future unforeseeable project impact of COVID, but now the parties are going to actually legally modify the contract. And why is that important? It's important because the parties are creating a legal transaction that'll be legally binding, right? And so it's important that the proper procedure is followed so that you can actually have a legal modification of the contract. If the correct procedure is not followed, although the parties may implicitly have some form of understanding, it's possible that the contract has not been legally modified such that the subcontractor can then collect for extra time and extra costs. And we see this most severely in public works construction projects. And so, for instance, the typical change order provision is going to require prior approval in writing, and that if there is no specific approval for that extra work and it's not done with the proper procedure in the change order, it may result in a potential waiver, like I said, especially with the public agencies. And the reason is that when you're dealing with a public agency, you're dealing with the public coffers, right? The public's money to perform work. And there is a long and thorough established legal precedent concerning how a public agency can contract with private parties. And the buzz term to remember is mode is the measure of power, right? And so if the mode that a local agency is given legally to contract is only through the board's written approval of contracts and change orders, then that's the measure of the power that public agency has to enter into change orders. If they don't go through that procedure, then they don't have the legal power and authority to bind a party in a change order. And you can end up with a contractor who performs the work, does a great job, may not have any disputes, but is absolutely not entitled to payment. And what's more, may actually be subject to liquidated damages, right? Because they never got a contract time extension. And so in terms of documenting the impact of the change, right? If we're talking about COVID, we're talking about, okay, let's document the impact of the project shutdown, the additional costs, the additional general conditions. You want to, I would say, almost manically document the labor, document the materials, document the equipment on a daily basis, right? Use your time and material tickets to document any type of activity at the project. And on public works projects, it's critical that your daily documentation that proves up your cost is accurate, right? If those documents are overstated or there's a misrepresentation in those documents, you may be subject to a False Claim Act violation, which carries with it some pretty substantial civil and possible criminal penalties. So when it comes to change orders, like we mentioned in COVID, there's not usually much dispute that the contractor is going to be entitled to something, assuming that the contract is not written against them. And the question really is this issue, what can you prove up in terms of project impact? This is the way to do it. In terms of change order provisions, the other thing you want to be aware of are full and final clauses that basically say, look, we've dealt with a change order. And this happens a lot of times where an owner may say, I'm willing to pay you give you extra time, but I'm not willing to give you extra money for that time, right? Field office, home office costs. And so they'll get a change order for extra time, but then there'll be a full and final clause in there that says this deals with everything. So for instance, in COVID, this deals with the full and complete COVID impact, and they get extra time. If the contractor is thinking in their mind, well, I'll submit a second change order for the cost of that time, my home office and field office, a full and final clause may legally preclude them from being able to do that, right? So again, understand what's in your change order procedure, find out what's in your change order form, and know and understand if there's a full and final change order clause. Now we get to our last two sections here, and we'll move through these quickly so we have a few minutes at the end. We want to look closely at the termination provision in a contract. There's two provisions generally that apply. One is for cause, the other is for convenience, right? For cause, you're defaulting one party who has failed to cure, and for convenience, it's basically for the owner's benefit in order to either stop the project or move on with somebody else. Notice provisions for any kind of construction project are extremely important. That they are followed exactly as specified. If the termination procedure is not followed exactly as specified in the construction contract, and the owner, for instance, terminates the contractor while not following the termination provision correctly, it can actually result in the owner being placed in breach of contract and the contractor having a legitimate claim for lost profits, et cetera. Because that notice provision was not, the termination provision was not followed correctly. So if you're being terminated, see if they're following it. And if you're going to terminate, follow it as specifically as possible. Let's jump to claims and dispute resolution. So the question usually arises, well, what do we do about claims? Here's a funny little graphic, but it highlights my experience with claims. Most claims are not two people in a real disagreement. It's two different people in two different universes arguing different things. And here, that essentially is what's demonstrated. And that's really the challenge in a claim or dispute resolution procedure is how do you get the parties to communicate talking about the same subject matter, talking apples to apples, so that then you can get them in the realm of being reasonable. And that's really what you need to look for in the claims and dispute resolution procedure. And so let's get into it. It's going to be contained in your general or special conditions, and there will be claim notice requirements. So we have general requirements for change order notice in your contract, but separately, you're going to have provisions for claim, right? Once your change order is denied, then it's going to turn into a formal claim. And those provisions for filing the claims are just as important as the change order procedures. The same potential negative consequences can apply there as well. And so, like I said before, you've got to follow these procedures. Otherwise, you can lose your entitlement to cost or time altogether. Greg Opinski, that case is a great example because the contractor was actually entitled to extra work and extra time, but didn't follow the procedures, and the city of Oakdale nailed him with a liquidated damages assessment. And even though the project record was clear, the contractor didn't follow the claim and the change order procedures to be entitled to a time extension and was legally subject to liquidated damages just because they didn't follow and understand the provisions. In addition to the contractual obligations, there are statutory obligations to bring a claim. And these are generally referred to as the Government Claim Act or the Government Code Claim that a party is going to have to submit. But for personal injury and property damage, there's a deadline of 6 months to file your government code claim. And for all others, it's 1 year. So a contract, if the owner breaches it and they're a public agency, you have 1 year to submit your government code claim. Otherwise, you may lose your claim altogether. On public projects, in 2017, the Public Contract Code was amended to include Section 9240, which is a standard claim procedure for public works projects. This procedure can be amended by the contract, but it cannot provide any procedure less than what is provided in Section 9240. And it generally requires a claim to be made, a meet and confer, a mediation, and then the parties are generally released to pursue litigation or arbitration. And so let's keep moving quickly here. But the claim procedure usually has some type of initial decision maker or party neutral to make a non-binding decision in terms of whatever dispute that there appears at that point in time. If the dispute cannot be resolved through that initial decision maker, the next step generally is to go to a mediation, which is confidential and privileged. And so it can't be used as evidence for any case that follows that mediation or an unresolved claim. If the mediation is unsuccessful, then the claim will move forward. And there's a variety of different ways it can move forward. It can move forward in the form of an administrative hearing through the Contractor State License Board or through the Office of Administrative Hearings. But the claim can also move forward in arbitration, right, which is just a private dispute resolution process that the parties agree to beforehand or at the time of the claim. The challenges with arbitration is that your appeals are limited, right? You get more control because if you're outside of the court and the parties have more say in terms of the schedule, but appeals are limited. And then lastly, we have the court litigation, right? If there's no initial decision maker or those have been exhausted, if the parties have a mediation obligation or that's been exhausted and it's unsuccessful, and there's no administrative hearing or arbitration requirement, then the claim is going to move forward into court litigation. And that's important to understand as well, right? Going back to these prompt payment claims and things like that, if you're owed substantial prompt payment penalties or damages, you need to understand the differences between being in court versus arbitration. The advantages of being in court is that it's all a public process. And most importantly, you can obtain provisional remedies like getting an injunction or receivership or writ of possession or writ of attachment, which you can't otherwise get in arbitration. So those provide additional tools to put you into a secure position to collect your money, to get a writ of attachment, for example. And so that takes us through some of the key contract provisions that we've covered. And just to recap for a second, and then I'll open up to any Q&A if we have time, we've talked about risk transfer, right, through this risk management process. We've talked about the law of force majeure and impossibility that applies in these COVID situations when the risk is now manifest. We've talked about the contract review procedure that should be implemented in the team members And then we've also talked about some of the specific provisions that you want to be aware of in terms of potential profits, potential losses, and the procedures that you have to follow in order to make sure that you are protecting your ability to recover those profits and losses. So I hope that has been beneficial for you. I'm happy to stick around as long as everyone wants to continue and ask questions. And if I don't answer your question here, of course, feel free to send me an email and I'd be happy to connect with you further.
Thank you so much, Aaron. That was great. I learned a lot as well. So yeah, let's open the floor. If you have any questions, feel free to raise your hand or type them in the chat and we can get to them.
Aaron, this is Ethel Rubio. How are you?
Hi, Ethel.
Great presentation. That was really enlightening to get a refresher course on on this topic, and especially covering the COVID. Just out of curiosity from your end, when I actually asked it on the chat, you talked about delays and who owns the delays. You kind of like enumerate them, but you didn't say anything about inspection. So if there's a delay in inspection from your end, who owns the delay?
Yeah, so in my experience, most contracts aren't assigning specifically, text that says if the inspector is delayed, it's the fault of the contractor or the owner or who absorbs that loss. That's one of those areas where it's not addressed. And so if it's not addressed, that's generally a good thing because you're not tied, and the doctrines of impossibility and practicability, frustration of purpose then are going to apply. And so if the inspector's delay or unavailability has nothing to do with the contractor's activities, then in that situation, the owner's gonna be responsible for that additional delay. Okay. Yeah, that's one of the more common ones that I've seen with COVID, because generally the owner and the contractor can come to an agreement. They want the same thing. They want to get the project done or whatever it is. But the inspector has tended to be the bottleneck in that process in order to continue to make the process.
It is. Thank you for that.
You're welcome.
Hi, Aaron. I have a question.
Sure.
So for example, let's say that we use one of the float days for something like heavy rain. Then do we get to also add on, like additional costs for like back office staff and like rentals and stuff like that?
So generally, no, if I understand your question correctly. So if you just have a normal rain day and you have field equipment and materials or labor or whatever that is, chances are you're not going to be able to recover the cost of that idle time from the owner because usually most rain delays are already in the contract, right? So it was foreseeable that there was going to be some type of delay. And if we're only talking about, a single one day or something, that's really within the historical pattern of rain, then it's not an unforeseeable, unknown future risk. It's actually a known risk that's foreseeable. And the cost consequence doesn't arise to that level of being severe and unreasonable, right? One day of costs when you already knew there was going to be a rain day, probably not enough to amount to a force majeure. I have cases though where you have 100-year rain that's just totally unexpected. Situations like that potentially can qualify.
Got it. Thank you.
You're welcome. Great question, Grace.
Thank you. Do we have any more questions? Feel free to just come off mute. I'll come off mute and ask. Okay, so I'm not hearing or seeing anything. Or actually, here's one in the chat. Sorry. Yep. Do you foresee that COVID will still account for any delays since things are quote unquote going back to normal?
I hope they're no longer accounting for any delays. But we know that the recovery process has been somewhat of a staggered, one step forward, one step back. So cross your fingers. I think the infrastructure for dealing with the COVID impact has been, really the construction industry, I should say, has gotten their arms around how to deal with that impact, right? Whether they will continue to be impact or not, hard to say, but it certainly seems like there's less and less impact, and it seems like owners and contractors are getting better and better at working out these impacts and working through the time and the cost issues that are related to them.
All right, any more questions? Okay, so I guess we'll call it a class. Thank you so much, Aaron, for your time and expertise and knowledge that you shared with us today. Like everyone's been saying, I was very informative and I learned a lot as well. So we hope to have you back soon. Thank you everyone for attending today. As I mentioned, please fill out the survey that was placed in the chat. I also put a link in for tomorrow's Navigating City Contracting Opportunities workshop, Councilmember Curran Price, and then information for the Metro Contract Development and Bonding Program Bidding and Estimating Academy that's starting next Wednesday. So if you need any of that information, stick around for 2 seconds. I'll put it back in the chat so you can get the link again and the contact information for the academy. But other than that, thank you all. Thank you, Aaron, so much. And we hope to see you guys at our next workshop or academy. Thank you and have a great afternoon, everyone.
Thank you, guys.